I am a lawyer and dedicated to identifying and attempting to free the wrongfully convicted in the state of North Carolina. I went to law school pretty late in my life. I already had my 2 children, who are both lawyers now too, so my work may be done, I suppose. But it took me a long time, and that's not, waiting is a beast doesn't refer to how long it took me to go to law school. But when I went, I was unabashedly in love. And I carried that sweet feeling about the law for a long time. This is where I want to be. This is where I want to do my work. That was so long before I ever got involved in wrongful convictions. Sadly, that work has changed my view, but I still think that we can try to restore some of that feeling that I have, but it's going to take all of us to do that. We also, for a time, believed that the criminal justice system in America was the best anywhere, that it never made any mistakes. But the number behind me, 325, reveals to us that mistakes are all too common. That's the number of people in the United States, men and women, who've been exonerated through the use of DNA evidence. And exonerated doesn't mean that it proved they were innocent before they were tried. Exonerated means that they were arrested, they were indicted in most cases, they were tried, they were convicted, and they were sentenced to prison, and they served time. These 325 men and women served an average of 13 and a half years in prison before they were exonerated and freed. 20 of those 325 people were sentenced to death. For these people, DNA evidence was a miracle. DNA was a miracle. While they were waiting on the world to change, it changed dramatically. DNA started to be used to identify the actual perpetrators and then be used to exonerate those who didn't commit the crime. What these 325 cases also did was provide irrefutable evidence that people get convicted when they're innocent. And it provided a wonderful research opportunity for fellow academics to look at these cases and dissect them and figure out, well, how do these people get convicted if they are indeed innocent? What are the factors that lead to their wrongful convictions? Those factors were identified, and we know them, right? They are faulty forensic science, false confessions, official misconduct by police and prosecutors, ineffective assistance of counsel, and of course, mistaken eyewitness identification. So we now had that laboratory, that wonderful laboratory to identify those causes. So now we're done. No, we're not done, right? So many cases have no biological evidence in them. DNA is available as exonerating evidence or clarifying evidence at the time of investigation only in a tiny fraction of cases. So in those other cases, those factors leading to wrongful convictions still operate, and they operate without the check the DNA provides. So there are these untold numbers, unknown quantities of wrongfully convicted people in prison, and they don't have DNA to help them out. The work I do at my clinic at Duke Law School with my colleagues is we work with non-DNA cases. So that's become sort of our default specialty. We don't have any cases in which DNA is present, so we have these cases without DNA. We decided early on that we needed a different way to approach these cases, right? We weren't going to be able to take DNA evidence to the judge or the prosecutors and say, you've made a terrible mistake. We also decided early on that we had to remove ourselves from the adversarial process that typifies criminal litigation. We knew that if you had an innocent person, that it was inappropriate somehow in a very fundamental way to think we're just going to go into court and fight it out with the prosecutors, right? If we have an innocent person and we believe we have the evidence to support that, there shouldn't be two sides to the argument. We should be able to persuade them they should join us. That sounds naive, but I want to tell you it worked. What we do is the process we've established is that we investigate our cases, and when we believe we have a case of actual innocence, we offer to the prosecutors to make a formal presentation to them, their team, their families, anyone who would be interested. We are transparent, we are open, we reveal. And that has been very effective. That was very effective at the beginning. I have one story to tell you of an effective use of this process. This is our former client, Noe, and Noe is with his mother in this photo, and Noe's pretty happy. Noe was released several weeks before that photo and reunited with his mother. This, however, is Noe when we met him. This is the Department of Corrections photo of Noe, and every time I met him while he was incarcerated, while we were representing him, he had that same etched look of despair and resignation, a combination of traits, characteristics that seems to affect all of my clients over time. So that's what Noe looked like. The reason I chose Noe's case to talk to you about is because it's sort of factually contained. All of the facts that you need to know to understand what happened in Noe's case occurred inside a 1995 Isuzu Rodeo, a car I will never get in after hearing this story. But it all happened in the 1995 Isuzu Rodeo. Noe and his brother Jorge and Jorge's two employees all set out in late January 2006 in Jorge's Isuzu Rodeo. They were hungry, they had been drinking, and they set out in the car. Jorge and Noe, the brothers, climbed into the front seats of the car. The two employees got in the back. In less than a half mile from the location they left, the car slightly veered off the right side of the road. Then, and I certainly have done this myself, there was an overcorrection, right? The driver overcorrected the car spun around into the other lane and was broadsided, T-boned, severely impacted by a Ford Expedition that was coming in the other lane and hit the Isuzu Rodeo almost dead center on the passenger side. These two photos show you, these were created by the police department, and the police department prepared these as a way to understand what happened, what caused the accident. This was their accident reconstruction. This was the evidence they created to go forward with the arrest and conviction. You can see that the expedition impacted the rodeo directly in the center of the passenger side. The graphic to the right is the Isuzu Rodeo. You can see how crushed it is. It almost has a perfect imprint of the front of the Ford Expedition on the passenger side. I have added these colored circles to indicate where the four occupants of the rodeo were. The brothers are in the front seat, and unfortunately and tragically, the person directly behind the driver died as a result of the accident when he broke his neck. What happened, we had this graphic created to illustrate where the two seats were, where the two brothers were. What happened in this case was that as a matter of physics, science, laws of physics, when the car was struck on the passenger side, the unseatbelted passengers, occupants of the vehicle, got mixed up in place. But what happened is that the two brothers' bodies lay across each other. That wouldn't have been a problem but for the fact that when they were removed from the vehicle, because the car was so severely impacted, the front of the Isuzu Rodeo had to be peeled back with the jaws of life. The big can opener that opens cars when they're impacted, and peeled back, and the first responders pulled the brothers out of the vehicle. And as you can see, as you can determine, what happened is that Jorge, the brother, the actual driver, was pulled out of the passenger side, and Noe, the passenger, the front seat passenger, was pulled out of the driver's side. The first responders, the very first responders who arrived, the very first people who looked inside the car when the brothers were still unconscious, identified where the feet were, identified correctly who the driver was and who the passenger was, and then memorialized that in their reports. The second responders who came with the can opener, with the jaws of life, they made official reports as well, but in their reports they didn't get it right. They pulled the brothers out of the opposite windows, and they wrote in their reports that I picked up Noe, and I picked up the driver. I transported Jorge, I was transporting the passenger. When we got the case a few years later, all we knew was that Noe was telling us that he was innocent. So we consulted with experts. We consulted with an accident reconstructionist of our own who didn't just focus on the outside of the cars and which car hit which, how the cars impacted each other, but we consulted with somebody in accident reconstruction who looked at the interior of the cars. What happens to 4 unseatbelted passengers when they get hit on the passenger side? We consulted with a fabulous engineer who creates graphics for us to help us understand. I'm a lawyer. Physics? If I could do physics, I'd be doing something else probably, right? So I said, I needed to see this. You need to take the official reports, take the first responders' reports, take the information from the accident reconstructionist, and give us a graphic that I and the other lawyers, and maybe the prosecutors at some point, if we go that route, will understand. And he created graphics like this for us. We also consulted with a trauma surgeon. The trauma surgeon looked at Noe's injuries and said Noe had a second right rib fracture. The trauma surgeon looked at everybody's injuries and was able to place them exactly where they were in the car based on physics and accident reconstruction and their injuries. Noe had a second right rib fracture, which is what's our strongest rib, I now know, to protect your organs, and it can only be fractured with serious blunt force trauma. For example, when a Ford Expedition hits you directly on the side. Based primarily on the injury sustained, the force vectors, and the science of collision reconstruction, but also supported by the positions of the occupants as described by on-scene EMS providers, Noel or Noe simply could not have been the driver. So we took that to the prosecutors, and the prosecutors eventually agreed with us, joined us in seeking relief for Noe, and the judge released him. I'm showing you this, telling you this story as a great success of our process. It worked very well. But I'm imagining some of you are thinking, this is her success story, right? This is not a great success. This never should have happened. But I'm showing it to you because it is a good example of the process that we need to put in place for these kinds of cases. We can't allow the adversarial system to work. Now, with our cases, no matter how many factors that lead to wrongful convictions are present in our cases, we are meeting remarkable resistance. That has to change, right? So people like Noe, they're all waiting on the world to change in a different way. This photo is of a current client. This is Derek. This photo was the last school photo taken of Derek before he was arrested at 16 and charged with the murder of a white man who was shot in the head from close range. Derek would have been 15, he was 15 at the time of the murder, and was arrested several months later. The only evidence against Derek was the testimony of 2 men. There was no other evidence. One of the men was his good friend, who was his co-defendant, meaning he was also charged with the murder. He was charged with being present at the murder. That man saw an opportunity. He saw an opportunity because Derek was not only just 16 years old, but even before Derek was arrested, he was exhibiting signs of serious mental illness. As a result of the trauma related to the arrest and the detention in the county jail, that process he accelerated. And before long, he was in full-blown schizophrenia. They convicted him. Against odds, we were granted an evidentiary hearing in December. For 3 days, we put on evidence about serious prosecutorial misconduct, serious errors in the investigation, very questionable tactics. So I'm waiting on the world to change, right? Derek is waiting on the world to change, but this is going to be a harder wait, because this wait is for human nature to change. We need to make it known that we want people to approach these cases fairly and openly with a commitment to truth and justice, and not just leave Derek in prison. We're now, because we lost that case, a couple of weeks ago we learned that we lost our opportunity. We were ruled against at the hearing, and we had to make the phone call to Derek and his family and say, you're spending your life in prison. So, we're waiting on the world to change. But in the words, and it's the title of my talk, in the words of the mother of another one of my clients, waiting is a beast, but you can help relieve some of that burden, and we all can help by making it known what we're committed to. So, thank you very much.